Everybody to the live briefing on accountability in transnational counterterrorism. I'm very glad to see a lot of familiar faces and names today who are joining us. Nevertheless, maybe some of you are not familiar with ICCT, so just a few words on ICCT. ICCT is a think and a do tank in the field of countering terrorism and preventing violent extremism. We conduct evidence-based research, we provide policy advice, we contribute to the development of good practices at different fora, we provide tailor-made training and workshops, in particular for practitioners from the criminal justice sector, but also for practitioners at local level, and we contribute to the public debate through our journal. So safeguarding the rule of law and adhering to human rights is central in our approach to countering terrorism. And the rule of law is more than just an end itself. A rule of law compliant policies, laws, can act as a means to address a number of root causes that drive radicalization and lead to violent extremism. Furthermore, accountability and oversight are crucial. This includes meaningful accountability for the full range of crimes that are being committed by terrorist groups. This means not only prosecuting alleged terrorists for only terrorist offenses, but also explore the possibilities to prosecute them for sexual and gender-based violence crimes, or potentially also for core international crimes. But accountability also means holding states accountable for abusive CT policies and laws. And finally, ensuring accountability and oversight for the Transnational Counter-Terrorism framework, which is the topic of today's live briefing. And we will delve into questions such as, why do we need accountability? And how is oversight and accountability currently regulated at transnational level? How effective and meaningful is this accountability? And how can accountability of the transnational framework be improved? Before I introduce to you the panelists of today, just a few housekeeping rules. The live briefing will be recorded, but that doesn't include the Q&A. Those for the Q&A, the Chatham House rules apply. The live briefing is also live streamed, and a recording will be available for all our registered participants at our YouTube channel. And please feel free to ask and pose any questions in the chat, and we will try to address as many as possible during the Q&A. So today we have with us three excellent panelists, and I'm really very pleased to finally actually do this live briefing, because I've been discussing this topic with Fiona, I think maybe already 6-7 months, if not even longer. And we were finally able to find a suitable date and a suitable setup to organize this live briefing. So for those of you who are not familiar with Fiona de Londras, she's a professor of global legal studies at the University of Birmingham. And a lot of her work focuses on the impact of counterterrorism, whether domestic, regional, or at transnational level on human rights. She has recently written an excellent book, The Practice and Problems of Transnational Counterterrorism, which I highly recommend you to read. In addition, Fiona is also one of our first rule of law associates at ICCT, so I'm very pleased to organize this together with her. In addition, we also have today with us Judge Kimberly Prost. And Mrs. Kimberly Prost is at the moment a judge at the International Criminal Court in The Hague. And prior to that, she has held many different posts relating to counterterrorism, international cooperation, and mutual legal assistance. But most notably, she was the first ombudsperson for the Security Council Al-Qaeda Sanctions Committee. And we have today also with us David McKeever, and he is a legal officer at the United Nations Counterterrorism Executive Directorate, and he has an extensive knowledge of counterterrorism, human rights law, and refugee law. And in addition, a lot of experience working within the UN. So with this, I would like to formally open the live briefing. And we are just keeping it a very general conversational style. And all of the panelists will be able to join. And hopefully also we can introduce a lot of questions from the participants. So I'll start with Fiona. What accountability concerns arise when we look at the transnational framework? Could you elaborate a little bit on this?
Certainly. Let me start by thanking you, Tanya, the ICCT, Judge Prost and David for for facilitating this and enabling us all to be together, albeit in this always suboptimal online format this afternoon. So you asked what challenges of accountability arise in the Transnational Counter-Terrorism framework. And I think to answer that, I want first, quite briefly, to say why I think we ought to be concerned with accountability in this context. So, as you said in your introductory remarks, Tanya, there are at least three ways in which we might think about accountability in the context of counterterrorism. One is the accountability of terrorist actors, one is the accountability of states, and the third, which we focus on today, is the accountability of processes, systems, institutions at the transnational level. And I think the reason why it's important that we spend time thinking about how and why that transnational architecture and its elements need to be the focus of accountability attention is that it is a remarkably powerful edifice, a remarkably productive and generative edifice that produces laws, norms, processes, politics, discourse, and ways of approaching and perhaps arguably securitizing everyday challenges that have real impacts, both on the international level, in national law, and critically in the intimate realm of the individual life. And so if we subscribe to the fairly basic proposition in political science that accountability should follow power, then the transnational counterterrorism edifice should be accountable in some way because of the powerful nature of that it has and the power of its actions. So what then become the challenges of accountability if we accept that basic kind of precept? And I think for the sake of just kicking us off, I'll suggest that it's quite handy to ask that question against the four very standard dimensions of accountability. Who is accountable, to whom, for what, and against what benchmarks? And I think in transnational counterterrorism, we see challenges in each of these four domains that are kind of familiar across global governance and international law, but are nevertheless worthy of attention here. So if we start with that first question of who is accountable, again, we have to understand it on the various different scales of transnational counterterrorism. So you have formal international organizations which are engaged in the processes of making and applying counterterrorism law and policy, and they should be accountable. But within that, we need to ask, where are the primary generators in terms of norm development or policy development? So what parts of that international institution have particular capacity to shape the discussion or shape the legal terrain? And at the UN level, that would draw one's attention, I think, to the Security Council in particular, given its capacity and willingness to develop resolutions in this field, as well as, of course, the General Assembly. And then these you might call managerial or organizational units, like the Office for Counterterrorism, for example, within the United Nations. But we also, I think, need to be conscious that this landscape in which counterterrorism is done, just to use a shorthand term, on the transnational level, is very heavily populated by non-formal or informal institutions as well. So I just mean they're institutions that don't meet the legal character of an international organization. So we have there institutions like the Global Counter-Terrorism Forum, for example, or other similar bodies, if we use that term, which are also very powerful. Now, they are not making hard law. They don't have that capacity, but they are generating soft law that is sometimes incorporated into hard law by Security Council resolutions or similar. And they are working often hand in hand in productive and important partnerships with formal institutions in ways that shape the translation of the international legal framework into everyday activity on the ground and at the policy level. And of course, then you have states, as key actors involved who should be accountable. Now, even just by outlining that very briefly, you see one of the big challenges of accountability is scale. It is just the number of actors in transnational counterterrorism, but it is also their nature. So these non-formal international organizations don't have the kinds of legal structures we're familiar with, can't be held accountable through conventional legal accountability mechanisms like court cases. The Security Council has a capacity in some ways to sideline some forms of accountability because of the structure and kind of hierarchies within international institutions and international legal doctrine. Although there are ways around that maybe we'll come to with the Caddy case as an example or whatever. But it's not just that there's a multiplicity of bodies, but also that both the number of bodies and their nature can make these actors the kinds of actors who are particularly challenging from an accountability perspective, political or legal accountability. The second dimension is to whom are they accountable? And again, we see these levels or different scales of activity raising accountability challenges with which I think we should be concerned. So ultimately, if you have a formal international organization, of course, it is accountable to the states, to its members. But again, you have to ask, well, how susceptible is that particular part of the institution, like the Security Council, to accountability action by the broader membership of the United Nations? We don't have to rehearse the ways in which that is institutionally challenging, and the ways in which the structure of the United Nations makes that especially challenging. We all know that these informal or non-formal organizations, in as much as they are accountable to their members, but their membership is selective, even though the effect of their actions is much broader than the persons who make up the states that are members of these organizations. So that there is potentially a disconnect between the persons impacted by the actions of these bodies and the persons or entities capable of trying to make these bodies accountable. So a disconnect between between power and accountability in some ways, when you think about those two dimensions. Thirdly, we have to ask what we should be asking the transnational counterterrorism architecture to be accountable for. And I want to mention here just three things, all of which are very challenging. The first is kind of system effects, by which I mean, if we look into, for example, the United Nations itself, in what ways is the generation and scale of the UN's counterterrorism architecture and activity distorting the organization as a whole? Sometimes it's quite difficult to see that distortion because it might be budgetary, or it might be about resource allocation, or it might be about certain topics becoming brought into the kind of bailiwick of, let's say, the Office of Counterterrorism that previously sat wholly or primarily in development or something like that. So is there a distorting effect within a system or within an institution? And do we understand that and kind of try to ensure accountability of some kind for that to whatever extent that is needed? Accountability doesn't necessarily mean a negative thing, just that kind of question of explaining, justifying, and knowing, that there is an effect. There are also, of course, indirect effects on individuals and organizations and activities through the implementation of the laws and norms developed at international level, either by states, including in bad faith, as you've already mentioned, Tanya, through the abusive application of transnational counterterrorism, or by other organizations or entities that are applying counterterrorism lenses, practices, or policies to people or entities in satisfaction of perceived international obligations. And then, of course, there are direct effects. So there is, as I'm sure Judge Prost will speak about, this reasonably narrow but nevertheless very significant portion of activity where the international intersects directly with individual life through the sanctions regimes, and now increasingly watch listing and things like this as well, where there is a direct relationship. And the final conundrum, or the final challenge, I think, is about benchmarks. So even if we were to all agree and want to create an accountability system, we would have to, I think, ask what the benchmarks for accountability are in transnational counterterrorism and how we can adjust them for the realities of transnational activity. So if participation, for example, is a benchmark that we would usually apply at a national level, well, how do we understand that at a transnational level? What constitutes sufficient participation or mediated participation of the polity via their state or civil society or what have you? Of course, there are these questions of legality as a benchmark, and that can be complicated by the fact that there may be kind of norm dilution or a disagreement about which part of international law actually applies as the test for legality. Maybe is it international humanitarian law or is it a counterterrorism standard, for example? So I know I've gone on a little bit, but just to kind of, I think, outline the scales and the kind of dimensions in which I think we can see and might want to discuss the challenge of accountability in transnational counterterrorism. Those for me would be the four: who is accountable, to whom, for what, and against which standards.
Thank you very much, Fiona, for laying out, I think, a good structure how we can continue the discussion. And I would also like to invite the panelists to respond to this. And I think we could also delve in a little bit more when it comes to the benchmarks, the procedural benchmarks, which is sometimes more a ticking of the box exercise, which can easily be achieved, rather and focusing more on some of the more substantive benchmarks, and also whether or not the same kind of benchmarks can and should apply to formal institutions and the informal institutions. As you say, they are really very different in how they have been created, and so is their mandate. So I would like to invite the panelists to respond. Maybe Judge Prost, would you want to reflect on what Fiona just said on the who, to whom, for what, and against what?
Yes, thanks very much, and it's always a pleasure to join in on this, one of my favorite topics of accountability in the transnational context. I'll make some more detailed remarks later, but it struck me, Fiona, when you were speaking about power has to be accompanied by accountability, and I think at the transnational level, this lies, at least from my experience, at the root of the problem, because there's simply no culture of accountability in certain contexts, and certainly the most sharply defined in that way for me was the Security Council. The idea of any form of accountability or any form of responsibility, even in terms of individual rights, was a concept that I felt like I was introducing for the first time when I took on the role of ombudsperson. And that, I think, is one of the major challenges, is what you've laid out in very clear terms as the kinds of accountability measures there should be, the criteria, the benchmarking, all of that makes eminent sense, but it's simply such a foreign context in the workings, especially of the large institutions. I would also say some of the more soft law institutions that you mentioned, there's a similar problem. They can be hugely influential, but their focus is always on their policy, what they're trying to develop, what their aim is. And in counterterrorism, it's dealing with the situations, understandably, wanting to address them, wanting to deter, to protect. But as a result, they too, I think, fail to see the importance of balancing what they're doing and taking into account all of the criteria that should be considered. It's simply a very different, as I'll talk about, a very different approach to policy making. And I think that for me is where all of what you're speaking to is extremely important, but it's very challenging to even get to step one, where these institutions are thinking about these steps and their obligations in terms of accountability. So I think I'll leave it there for the moment, but that was really interesting introduction, and I'll come back on some of the points when I make some comments later. Thanks.
Sure, thank you, Judge Prost. David?
Thanks very much.
Thoughts?
Sure. Thank you very much. And I'm very grateful to have been invited this morning. It's a pleasure to participate. I mean, I agree with an awful lot of what Fiona said. I mean, maybe one comment to push back slightly, and then, well, two comments and a question, perhaps. I mean, on the underlying factual premise, the idea of this edifice being remarkably powerful, I don't necessarily disagree, but I think the impact of certainly the Security Council's counterterrorism architecture is mixed. I think it's uneven. And I think it is always important when we're considering the consequences of this architecture to bear in mind the agency of states. It is not the case, and from what I've seen in my work, that as soon as the Security Council resolution on terrorism is adopted, that all states automatically proceed to implement it. The reactions are mixed. And one reason for that, I mean, speaks to the point which Fiona makes very clearly I mean, she just made it now, but also she makes it in her book. It's just the volume of material we're talking about. A lot of states simply don't have the bandwidth, either in New York or certainly in capital, to process and to react to all of the rules and the soft law norms that are being introduced. So I mean that I think is one part of it. I mean, Resolution 1373 I think is in a slightly different category here. That was very well known, enormously impactful domestic legislation, and of course ratification rates of the treaty. So 1373 I think is slightly different. But as we look at what's happened since then, you know, states react in different ways. States have different priorities here. States will make choices based on domestic political pressures or the nature of the threats they face or their bilateral relationships and resource priorities and so on and so on. Again, that's not to suggest accountability isn't important, but just if we're talking about consequence of this framework, I think it is important to remember that it operates in a different way in different member states. I mean, the second comment is just on the point on civil society engagement. And I mean, as Fiona knows very well, this is something we're trying to do better, do more of in our work. I mean, I'll come to CTED in more detail in a moment, but just to say for a moment that as we try and engage with civil society actors in a more systematic and a more meaningful way, there are challenges, of course. I mean, one of which is that it is not always the case that a civil society actor is indeed independent of the government in question. That's one challenge. Another is that we need to be cognizant that in some circumstances, by engaging with us, the civil society actor may in fact be putting itself at risk. So that's not a reason not to do it. It's just kind of some of the practical things we come up against. I mean, the question I had, it sort of fits in with my own things I've looked into previously in this area, and that is the respective advantages and disadvantages of using treaties to make law as compared to Security Council resolutions. And I just wonder how many of these concerns that Fiona has so clearly outlined, how many of these could have been avoided or mitigated if all of the same rules, all the same content, all the same volume had been introduced by treaty. So with treaties, you don't have the same concerns about democratic deficits or legitimacy, perhaps, that you have with respect to the Security Council. Equally, you don't have the same monitoring mechanisms, at least with respect to the CT treaties. Domestically, you do perhaps still have challenges around a state's decision to ratify treaties usually not justiciable, but perhaps you don't have the same obstacles. So not to kind of go down the road of a counterfactual, but just trying to specify where the problem is coming for, if it's as much the method by which the law is made as the law itself. So thanks again, just a few thoughts from my side.
Thank you very much, David, for sharing some of your remarks and indeed pointing out not only the volume of the Security Council resolutions, but also the documents that are being produced by the informal institutions are quite vast, and also actually the differences. Yes, 1373 is maybe a bit different because it does require member states to criminalize financing of terrorism, which already was covered in a convention, whereas the other two resolutions, 2178 and 2396, are novel in the sense that they are requiring member states to criminalize additional acts very much more in the pre-crime space. So I think it's not only the process we need to look at, what are they requiring states to criminalize, but also what acts are they requiring states to criminalize? So the process and the content, and there you see indeed a shift taking place. So maybe David, to continue with you, so what is the contribution of institutions within the UN, such as CTAT, in maybe also contributing to this transnational framework, but in particular in understanding and addressing these concerns of accountability?
Sure. Thanks, Tanya. Just initially on the reference to UN institutions, another point which Fiona makes very clearly is that there are now quite a few UN institutions who are involved in counterterrorism in different ways. In one category, you could maybe say there are those for whom counterterrorism or CV is their exclusive focus, or at least their primary focus. So that would be the Security Council committees and the bodies established to support those committees, one of whom I work for. Office of Counterterrorism, of course. And then maybe in another category, you have institutions like, say, UN Office on Drugs and Crime, for whom counterterrorism is a part of what they do, but it's not all that they do. And I think the accountability issues and perhaps the appropriate response mechanisms are going to vary, because these different institutions are involved in different ways. We all work together, we all interact, but ultimately we perform different functions. And so response mechanisms may differ. So one obvious example would be, it was mentioned earlier, the establishment of the Office of the Ombudsperson, which responded to a particular issue in the sanctions regime. And obviously Judge Prost can speak to that better than I can. On CTED specifically, just a very brief introduction. I don't assume that everybody's familiar with our work. Obviously, when the Council adopted Resolution 1373, in addition to imposing the legal obligations you mentioned just now, Tanya, and calling for additional steps by all member states, it also established a counterterrorism committee to monitor states' implementation of these rules and these measures. And then a couple of years later, the Council established CTED, an executive directorate, to support the work of the committee in this regard. And we do this, we support the committee primarily through conducting in-country assessment visits or desk-based assessments. During COVID, we had to kind of combine the two. And the purpose of these assessments are to ascertain how each of the 193 member states are indeed implementing all of the provisions in all of the many council resolutions. I'm happy to get into the mechanics of how this works in the Q&A if there's interest. But on the accountability point, and again, Tanya, I think you laid it out in your introduction, there are different ways of conceiving of accountability, or different types of accountability. And first, again, the point that was made about the accountability of those responsible for the commission of terrorist acts. That's obviously a huge part of what we do. That's a central part of the Council's counterterrorism framework. States are required to bring to justice those responsible for terrorist acts. And so it's a big part of what we do in our assessment work. So we will look at, we will assess, domestic criminalization of the offences. What kind of prosecution capacities does the country have in terms of counterterrorism? How has the country responded to new ways of prosecuting terrorist crimes, or new evidentiary challenges in terms of counterterrorism? And then the second type, again, of accountability would be the accountability of states for the violation of human rights that occur in the name of counterterrorism. And this happened before 9/11 also, as we know, but it's a big part of what we look at. So in our assessment work, we will also look at the underlying domestic definition of terrorism, which is enormously important, of course. We look at the breadth of ancillary offences. We'll look at criminal procedure rules, the increasing use of administrative powers in CT. I mean, that was referred to a moment ago. We look at oversight mechanisms. So in terms of our contribution, both those dimensions of accountability are fundamentally a part of every assessment we do, either in country or desk-based. But then the third kind of dimension of accountability is that I think Fiona and others, including the Special Rapporteur, have articulated concerns that the way in which our assessment work is conducted is itself problematic from the perspective of accountability, specifically that there is a lack of transparency. And again, as was mentioned, transparency being one part of accountability and an important part. And listen, it is true that our assessment work is confidential unless the state which we have assessed expressly consents. Then neither the report of the in-country assessment or the desk-based assessment are made public. There's one exception to that. Finland made their report public, which we were very pleased, but most states do not. So that is a reality, and I think it is true, certainly. I mean, again, Fiona has laid this out in her book, that this confidentiality poses challenges in terms of accountability. But maybe from our side, just to kind of flag 3 points on this, as to maybe why we have this approach and what we're trying to do about it. Firstly, the reality, I mean, as we all know, a confidentiality first approach is almost the default in this field. Even domestically, there are a lot of examples, and there are a lot of tragic examples of one domestic institution failing to share terrorism-related information with another domestic institution, in a timely manner. There are plenty of examples in all regions whereby domestic security or intelligence agencies will oppose the disclosure of counterterrorism-related information in domestic court proceedings, let alone international. So domestically, we have this issue. And then when you take a step back to the international level, obviously these same domestic actors are going to be reluctant to share some of this material with an external actor. And I would say they're going to be even more reluctant to do this if they believe that that information will subsequently be made public. So from our perspective as CTET, I think there's a legitimate concern that if the confidentiality of the process were to be lifted entirely, I mean, there's a halfway house, which I'll come back to in a moment, but if it were to be lifted entirely, the result might be that some countries are far less engaged in our processes, or at least don't share the same information with us. So that's maybe the kind of pragmatic side of it. And actually, if you look at some of the work of other international organizations in national security or counterterrorism, be it the ICRC or ICAO, you'll see a similar realization that confidentiality is necessary. Second thing to mention is that not everything we do is confidential. Over the years, CTET has published quite a few analytical reports looking at different themes. And they don't name and shame individual states. They don't say state X is violating rule Y, but they do draw on the country assessments. And I think they do have some useful information on our topic. So one example is we have these periodic global implementation surveys. I think the most recent is 2021, and that essentially looks at practice in all regions, in respect of all the resolutions, what's gone well, where are the challenges, what are the recommendations, and so on. So if you look at the most recent example, you can see that in any region you're interested in, how many countries in that region have problematic domestic definitions of terrorism, or how many countries in that region have oversight mechanisms which are not sufficiently independent or are not sufficiently well resourced. So again, I think these are germane to accountability. And another point which I think Fiona makes in her book is that transparency of method is very important here. And I think it was 2020, CTET published our revised methodology on how we conduct assessments. So I think that's useful. Again, I'm happy to get into the details more. And the final thing, sorry, I've gone on a bit here, Tanya. The final thing I'd mention would be, I think the Security Council is aware of these criticisms, and I think it is responsive to them. And since 2018, we have been directed to share our assessment reports once they've been adopted by the Counterterrorism Committee, to share those reports with our partner organizations. And what this means in practice is that I think it's now 45 international organizations, mainly UN, but not exclusively UN, with whom we work, get a copy of the adopted report. And just to mention that these aren't just like hard CT entities, they're also UN organizations working on human rights, working on humanitarian assistance and so on. This doesn't mean that they're public. The reports are still not public, but it does at least mean that there's some transparency, some sharing, some opportunity for dialogue. So it's an evolving process. We're trying to get better at it, but I think that is something worth mentioning. So I'll stop there for the moment. Thanks again, Tim.
Yeah, thank you very much, David, for your candid answer on strengths, but also some of the weaknesses in how to ensure accountability and the problems you're facing within UNCTAD. And I think one of the things what struck me is, the problem is not only mechanisms which are there to monitor the accountability, but if the language of a UN Security Council remains very vague, it gives a lot of leeway in the end to member states to criminalize acts or establish databases and say it is still within the purview of a UN Security Council resolution, making it very difficult indeed to monitor that. And I think in addition to the transparency, also how often is a country visit taking place? I mean, there is of course a limit on resources in how closely you can actually monitor when states are adopting policies and laws. But I mean, I would like to give first the floor to Fiona. What any thoughts, any additional thoughts on the problems on accountability within UNCTAD or other UN organizations? We are certainly not singling out only UNCTAD here.
No, certainly not. I mean, I think that I really appreciate David's account, and I think it is true to say that CTAD is per se an important part of the accountability mechanism in transnational counterterrorism. So I think one can say, as I did in my book, that CTAD is both an enforcement mechanism and an accountability mechanism. I think it's kind of framed or presented as a supportive or implementation support mechanism, but that has, in a kind of socio-legal sense, one would understand that as an enforcement type mechanism. But, just connecting a couple of things that everyone has said together already, I think for me, the thing that is challenging is that the focus is on the state. So this is not CTAD's fault, but the focus here is on how does the state act? How does the state implement these obligations? And there are three things I think that are tricky about that. The first thing is that it creates perhaps a kind of dislocation of the state. So of course, as David said earlier, states have agency, and the way that they will react to particular resolutions will vary widely across states. But it is also the case that the way in which the international system frames or presents or creates a set of obligations or a set of standards, to some extent creates or delimits in some ways, or shapes the amount or the leeway for that agency that the state has. So the focus on states, which is true of the Special Rapporteur as well, although she now focuses a lot on the UN as well, it raises the difficulty that where there are problems, those problems become conceptualized as a problem of states and state behavior, which of course they partly are. But what is the mechanism? The missing link, this isn't CTAD's fault for me, is linking that back into what is happening at the transnational level to kind of create spaces in which those difficulties can arise. And that then relates to the sort of second point, which is something that Judge Prost said, and I think is absolutely critical here. And that is about a kind of a culture of accountability. You know, I'm reminded of the really classic work in accountability of Mark Bovins, where he says to understand accountability, you have to look at the mechanisms and what he calls the virtue of accountability. Is there a mindset? Is there a commitment to accountability and to seeing the relevant actor as an entity that may be responsible for some of what happens within this bigger kind of ecosystem? And, you know, that challenge can, I think, only be exacerbated by the fact that the accountability systems as they exist primarily allow the focus to go towards the state, as opposed to looking back. And so I think, as David has mentioned, that those thematic analyses are really, really important, and that entities like CTED have access to a unique body of data that they can actually use to try to see systemically what kinds of things are happening, what is not unique to particular states or a particular kind of state, and what might be the connections back to, you know, the ways in which certain problems are framed or certain obligations have been drafted or whatever at the Security Council level. But I also recognize that there is a significant challenge for CTED. You know, CTED might not be the body that can do that, but the question would be, how do we then enable some other body to engage with that data to be able to do it? And if, we may come to this later, but if the suggestion in the 7th review of the Global Counterterrorism Strategy, that there might be a review, an independent review mechanism for UN counterterrorism, if that were developed, that would be the kind of entity who could perhaps create an or catalyze some kind of reflexivity in a way I think CTED would not be able to do, maybe as well as they might want to.
Judge Prost, I think I see you wanting to say something, and I know certainly you have a lot of experience in this area. Would you want to add something to the discussion on the role of formal institutions and their challenges in achieving accountability?
Well, thank you very much. And yes, I was just, Fiona's last comment was really interesting to me because I'm off on a day job at the moment that's a little bit different outside the CT field. I haven't been following the reviews as I used to. And so I find it very interesting that they're talking about even theoretically such a review mechanism, which of course I would find a very exciting prospect for addressing some of these issues. But the idea that actually arising in reality to me seems to be quite a challenging concept, but very interesting comment. Let me just start. I wanted to speak a little bit about what I think are some of the challenges in perhaps the culture and the way at the transnational, international level things develop. But before I do that, David, I wanted to comment on what you said, because I had that in the back of my mind as well. One of the solutions, or at least a partial solution, is of course the use of treaties, in my view, because a treaty negotiation process builds in by necessity, because you have all of the states generally participating, or a good number of them. You get a much better balance in terms of the protection of rights and the reflections on the needs to limits to measures when you have a treaty negotiation. And if you look at the CT treaties, they have had quite an effect on domestic law over time, and encouraging the proper use of extraterritorial jurisdiction, for example, improved extradition, those kinds of important measures. But of course, the problem is with treaties, at least for those who are driving a lot of the counterterrorism policy internationally, is first of all, states have to agree to sign on, exceed, and implement the treaties. And while there's been a lot of political pressure that has made the CT treaties quite popular, it was in fact one of the reasons that 1373 mentioned the financing convention and made it basically politically impossible after 9/11 not to sign up to that treaty, because it wasn't as popular as the others, because it involved much more difficult measures to implement than some of the previous treaties had done. So basically, I think those making the policy get impatient with the idea of going the treaty route. And of course, we've been stuck with the Global Terrorism Treaty for how many years now, not being able to agree. So the fact that you need agreement on the text, and then you need accessions, and then of course, you don't have the clout for implementation that you certainly do, for example, with Security Council resolutions. And while I recognize that, yes, of course, not every state by far has implemented even a quarter of what some of these resolutions, especially the most recent ones, which are so broad, has provided for. The danger for states is, especially when FATF gets involved in these enforcement, is that they face real practical consequences for not implementing in a speedy fashion, sometimes even measures which have absolutely no relevance to a lot of states. So in CT, there's more success rate, but it's for the wrong reasons, in my view, than there might be with other resolutions. And let me segue from that then to say that one of the problems in terms of, and it's the case with a lot of international initiatives, is the development of these resolutions, particularly at the Security Council, but in other institutions, is always reactionary. Unlike in a national context where you can at least have some kind of a policy development, most states will start from a policy position. They will actually work through a lot of the obvious issues of how will this impact, for example, on individual rights? How does this intersect with other measures that may be in existence? In a national domestic context, that goes on, not everywhere and not in great detail in some places, but you do have those considerations. That never happens at the international sphere, or very rarely, unless you're doing a treaty negotiation. And the problem is, if you look at the history, particularly in CT, Resolution 1267, which created the list of the Taliban Al-Qaeda list, the original one was originally just Taliban and then Al-Qaeda added, had a purpose, which was to get the Taliban to turn over Osama bin Laden for prosecution for the attacks in East Africa. That was the original purpose, but over time it morphed completely, and especially after 9/11, you see hundreds of names going onto that list, and no one had stopped in that whole process to think, what does this mean, especially for those individuals who are now on this list in terms of the measures that were applied to them. That's one example of the reactionary nature of this work, and it's exactly the same thing with 1373. I agree entirely, 1373 has been a very effective resolution, but it was basically a shocking step in instructing states as to what legislation they should adopt. It was basically legislating the requirement basically to join the financing convention, the creation of a monitoring mechanism. These were all extraordinary steps, perhaps very valuable in terms of the fight against terrorism, but there was no policy development in the creation of this. So when it comes to building in that basic accountability and safeguards, that there simply isn't none of that. And you can go through many examples of that in at least Security Council resolutions, in even the GA and other institutions. And so that's, I think, part of the problem that we face in trying to then introduce it afterwards. Because I can tell you the second problem that then arises, I mean, it was 7 years until the Caddy case, a very bold decision from the European Court of Justice. It took 7 years despite massive criticism from all directions about the 1267 list and about the Al-Qaeda sanctions regime and the unfairness of it. You know, there was no, at the beginning, there was no notifications, no reasons, no remedy, no recourse. You couldn't even talk to the Security Council. No one considered that the Security Council doesn't talk to people. It's not a warm and fuzzy body. So it was basically imposing these restrictions without any thought. And that was in place, and it took years to get any kind of movement from the Security Council. to introduce those measures. So motivation becomes a problem after these measures go into place, simply because there is no culture that thinks there should be this kind of accountability, this kind of counterbalance for individual rights. And we look at the same thing. We're over 10 years with the ombudsperson operating with respect to the Al-Qaeda sanctions regime. We've been calling repeatedly for extension to the other targeted sanction regimes, still no movement. So there's still individuals sitting there with no recourse in other contexts. So I say all that simply to emphasize that to me is the huge challenge, to get perhaps more thought at the beginning, and then to try and devise motivations to introduce the better balance and to account for the actions of the measures being taken. Just a few points I wanted to also highlight. I think part of the challenge for having the effectiveness of the measures being considered, and also this balance with human rights, is first of all the lack of clarity as to the purposes for which these measures are introduced. I've spoken about this before, Tanya, you've heard me before on this, because there tends to be a muddling of the kinds of measures. So for example, using sanctions, but not using them for the classic purposes of sanctions, which are, as we all know, stigmatizing, changing or inducing, motivating change of conduct, and deterrence and prevention. But it's used instead as a system of penalties without any of the protections of the criminal justice system. And you see this merging going on. What is the goal of this system? Is it really about those classic sanction purposes, or have we morphed into trying to use a shortcut to punish individuals through the use of sanctions? And similarly, when you see the mix with asset confiscation and freezing regimes, here there's a huge problem which only continues to grow larger, in that sanctions are about freezing assets for a purpose. They're not about confiscating assets for a different purpose. And we're starting to see a mix of that. And the lack of clarity in itself creates a whole issue of not only individual rights protections, but of accounting for these mechanisms, in my view. And then there's simply the fact that the idea of the rule of law has become almost words you can't get into resolutions. It's become almost offensive language to mention it. And so those basic protections, when you speak, I remember thinking I'm banging my head against a wall here when I was trying to explain why reasons were important, for example, in the decisions on delisting or not delisting, because the basic concepts of the right to know, the right to have reasons, the right to have an effective independent remedy, are all concepts that are really foreign to the operation of a lot of these institutions. And that in and of itself, of course, remains a major challenge. So I think I'll leave it there. I'm happy to respond to questions, but those were really some of my preoccupations and on the topic. Thanks.
Thank you, Judge Prost. And indeed, some of the words I've heard before, but I think they are still as valid now as they were a couple of years ago. And I think the discussion about, whether or not, treaty making would be, in some cases, the more, the route to go to, but it is a long process. And there comes UN Security Council resolutions that basically offer a shortcut, and they can be very reactionary. But what I do think we should also not underestimate is that a lot of the CT laws at national level are also becoming reactionary, like post-terrorism attacks, whether it's in France or New Zealand or in Austria. There are several countries where they also rush into those. So you see that certain habits which are at international level are being picked up at national level, and it should be the other way around, that the good habits should also be picked up at international level. But I think more due diligence, if that may be the right word, before you start at the transnational level in expanding could be indeed one way. But Fiona, what are your thoughts? I mean, how can we improve the accountability at transnational level? And do we want to make a distinction between accountability of formal institutions and informal institutions?
Sorry, my phone just rang there, which was very unhelpful. So just to respond, I think, well, first of all, if I can pick up on one thing that Judge Prost said, and it is around process. You know, it's very easy to get hung up on process, so I don't want to do that. But I do think this point about policy formation is super important, because, you know, it is not unique to the UN level to say that our ordinary expectations of good governance are often kind of suspended when it comes to counterterrorism, not necessarily for bad reasons. So one doesn't have to have a nefarious motivation for this to be the case. But this idea that there should be, you know, a culture of justification, there should be an assessment of necessity, there should be an assessment of rationality, there should be an explanation of why we're doing something, and critically later there should be an evaluative review, and we should be open to changing what we're doing. Those things, for multiple reasons, are really difficult to achieve in counterterrorism at every level. But one thing that I think is very interesting, and it picks up on something you just said, Tanya, is that let's say the deficiencies in policy formation at transnational level, and let's say in particular in Chapter 7 resolutions, though I know that they're rare in this field, they have significant downstream effects. Because when it comes to national or regional level, like in the European Union, an instrument will be designed in order to give effect to the Security Council resolution, and it will not necessarily undertake a robust policy formation process. And indeed, it will be treated as presumptively proportionate and legal because of its provenance in a Security Council resolution, even though the Security Council resolution did not have a robust process that underpinned it. And a good example, I think, relatively recent, is the EU directive on combating terrorism and the measures there around foreign terrorist fighters, where, you know, the memorandum effectively says this is proportionate because it comes from a UN Security Council resolution, which was subsequently incorporated in the additional protocol to the European Council of Europe Convention, and therefore everything is fine, which, you know, it manifestly isn't in terms of robustness. Then you asked me, Tanya, about how we improve it. I have to say that writing this book was one of the most disheartening intellectual experiences that I have had, because I largely failed to see means of meaningful improvement. And I think that this is because of what I perceive, and Judge Prost has also mentioned, as this kind of virtue or culture problem around the basic proposition that this system ought to be accountable, and that it ought to be accountable because it affects us intimately in our everyday lives. You know, not only because it distorts the system, or maybe it dilutes the division between different kind of laws of armed conflict and criminal laws, but also because of its intimate effect on everyday life. And in the absence of an acceptance of that kind of proposition, all we can do is fiddle or mitigate or make a bit better than it is. And I do think there are ways that things could be made a bit better, and that would include thinking really seriously about this proposition of an independent review mechanism to review the UN's engagement in counterterrorism and its partnerships. I agree that it seems to me unlikely that it would be established. And if it were established, unlikely that it would have sufficient permanence and meaningful independence to be effective. But, you know, maybe baby steps, maybe bit by bit. But I'm afraid I struggle to offer much particular optimism in respect of this, because of the cultural kind of challenge, and, you know, arguably also because there are many powerful actors for whom the lack of effective accountability is positive, is welcome. And what incentives, I think Judge Prost, you talked about motivations, what incentives do they have to subject themselves retrospectively now within a system designed without accountability or indeed rights at its heart to these limiting principles? I mean, not many, right? So yeah, I'm afraid I don't have anything hugely hopeful to offer.
Maybe our other panelists are maybe a little bit more optimistic and may have some thoughts on how it can be improved. David, maybe first to you. I mean, since you're have such an experience working within the UN, I'm sure it's something, you have also discussed many times with your colleagues, and I know you're speaking, in a personal capacity, but, I'm curious to hear your thoughts on, how can accountability be improved?
Sure. I mean, I certainly don't have any all-encompassing solutions here. I mean, I think a lot of the analysis that Fiona has summarized there is right. I mean, there have been efforts to mitigate here and there. From my perspective, I possibly see those as slightly more significant than I think Fiona does. But I absolutely take the general point that it has gone so far, the architecture is so large, and that it is difficult to see a quick fix. I mean, a couple of quick responses. First, on going back to the point about treaties, and also I think Fiona's point about the exceptionalism of CT. I mean, when I try to look at this as a public international lawyer, why is it that we have different methods of making law in this field? Why is it that treaties work in all these other fields of international law, but we need something exceptional for counterterrorism? The fact that a treaty takes time, to Kim's point, is a good thing in many cases for all the reasons that she outlined. I mean, the Convention on the Law of the Sea took 9 years to negotiate. The Human Rights Covenants took a long time to get from the Universal Declaration to the Covenants to them entering into force. But there are many positive dimensions to that. And the fact that states can enter reservations, the fact that states can terminate a treaty obligation if they so want, these all encourage adherence, I think, and an important part of the treaty infrastructure. The regional developments, I mean, Fiona mentioned there the EU directives. There are some, I think, potentially positive developments there, certainly not in all regions, but the 2017 EU directive obviously has a very interesting provision on the protection of humanitarian assistance, which is something that the Council has looked at also. So we'll see how that develops. I mean, maybe just to finish off from my side, not so much on solutions, but a kind of an interesting comparison as we think of accountability and compliance and so on is our work and the work of the Financial Action Task Force. I mean, Fatah was referred to a moment ago. Their mandate is different from ours. They look at money laundering and proliferation financing in addition to counting the financing of terrorism. There, as a technical international legal matter, they don't necessarily have lawmaking power. In fact, their mandate says they don't. But nevertheless, their recommendations are hugely important. And you see this really interesting pattern whereby the FATF will adopt a recommendation, which at the moment of its adoption is not a legal rule, but then the Security Council reacts to it, either encouraging states to apply the recommendation, or in some cases, actually changing the provisions of its own resolutions to give that recommendation, technical legal effect. And so therefore the FATF has a huge influence. Its reports are public. I mean, going back to what I mentioned earlier about transparency, very detailed, very technical FATF reports are public. And I think that's helpful, that's important. And in terms of potential penalties for states or the impact, you have the grey listing process, which again is public. So one of the theories of why states comply with international law is the idea of reputational risk, that it's not just about complying with a particular legal rule and the cost benefit, it's about the overall perception of that state being perceived as complying with international law generally. So going back to CTED, I mean, to what extent is there reputational risk when the process itself is confidential? There's far more reputational risk with the FATF process, and that may be one reason why I think they're more impactful. And on the accountability side, I don't want to mischaracterize Fiona here, but if I understand her correctly from her book, I think she and others see some positive developments on the FATF side in terms of engagement with civil society actors, and again, the transparency of the process. So just mentioning it because it's an interesting comparison to what we do. And, we are all friends with FATF, I don't want to suggest otherwise, but it is a different method of working on some of these same issues. So I'll leave it at that. Thanks, Tanya.
Thank you, David. Judge Prost?
Well,
considering your experience, anything you want to add on possible ways of improving the accountability?
Yeah, just briefly, it's interesting because I have quite a different take on FATF than David might, but in fact, I see FATF as a body that was designed to originally try and encourage the development of measures, which has now become more of an enforcement body. And CTAD, on the other hand, which I have a lot of respect for the work they've done, started out very much as an enforcement as a part of CTC, and then CTAD to enforce the resolution, but has made a huge contribution, I think, to developing accountability and transparency in processes and to assisting with implementation. So I think the kind of work that's been done, which may not have the clout, but I'm not in any way convinced that the clout method is the best way to certainly to develop measures which are balanced and which are effective. And I think there's a lot to be learned in the positive side from the work of the body like CTAD. I say the same thing about the monitoring team for the 1267 committee. I think they've done tremendous work in not only working on implementation enforcement, but they were a driving force as well in the creation of the ombudsperson position, so recognizing that balance. So I think there is hope in those ways with some of the mechanisms which take on a bit of a life of their own. And also, you know, I'm Canadian, so we're endlessly optimistic, right? It's our makeup. And, you know, the ombudsperson was a tiny step, but it moved step by step. And we now have a fair process mechanism which has binding effect, basically. It's never been overturned. And with respect to decisions that emanate from the Security Council, I think that's an extraordinary step. It took time. So I like the fact that someone started to mention this review mechanism, and it may take time. But I think initiatives like that, we have to remain optimistic and continue to work on them. So that would be little steps, as you said, step by step, Fiona.
Yeah, thank you, Judge Probst. And I think indeed there are a lot of lessons that can be learned of the different accountability mechanisms that are already there, but for different kind of institutions. And I think that can be indeed useful. And I think if you want to also develop like meaningful accountability, I think we will have to distinguish between the different institutions, whether it's the UN institutions and the informal institutions. The way GCTF works is not the way FATF works, it's not the way the UN works. And for each of them, you will need to, depending on the type of work they're doing, the impact they are having on human rights, the process of how they are working, and in particular the transparency, there will be different kind of benchmarks which might need to be developed, but maybe also in addition to this independent review mechanism, there can be also like an independent review mechanisms where NGOs and academics are taking part, which could also look at how the informal institutions also work. So I think, yeah, it is going to be a step-by-step process, but it is certainly, it doesn't mean that there is no need to continue working and improving the accountability and the oversight of transnational counterterrorism legal framework. And I was wondering, as one